Vamos a iniciar en 3, 2, 1. We are online now.
Great. Thank you so much. My name is Graham Reynolds. I'm an associate professor and the Associate Dean, Research and International at the Peter A. Allard School of Law at the University of British Columbia. It's a pleasure to be speaking with you today. My thanks to the organizers of this wonderful event. I was really excited to see the range of speakers that'll be presenting over the next few days and look forward to attending many of the presentations. My thanks as well to the interpreters. I'm grateful to you for working together to help share my talk to a broader audience than might otherwise be the case. So thank you. In my talk today, I'll discuss Canada's fair dealing defense. I will argue that it's both critically necessary and constitutionally required, in that a Copyright Act without a fair dealing defense would not survive constitutional scrutiny under the Canadian Charter of Rights and Freedoms. Now, I haven't come across any proposals for reform that have seriously suggested removing fair dealing from Canada's Copyright Act. Yet every day, individuals' fair dealing rights are waived or precluded by contract. And the Copyright Act permits this to take place. So aside from one provision relating to reversionary rights, which applies notwithstanding any agreement to the contrary, the Canadian Copyright Act is silent as to the ability of parties to modify aspects of the Act by contract. In light of the importance of fair dealing for the protection of the right to freedom of expression in the context of copyright, as well as a number of other rights that are protected internationally under human rights treaties, I argue, among other recommendations, that Canada's Parliament should take steps to confirm that any attempt to limit or waive fair dealing through contract is void. I'll start by providing an introduction to fair dealing. Fair dealing in Canada is the broadest defense to copyright infringement set out in the Copyright Act. Under the fair dealing defense, individuals have the right to use a substantial amount of copyrighted expression for certain purposes. And those purposes are research, private study, parody, satire, education, criticism, review, and news reporting, as long as the use is fair. Starting in 2004, the Supreme Court of Canada signaled a shift in their interpretation of fair dealing. Rather than conceiving of fair dealing as an exception or limitation that should be interpreted narrowly, as a derogation from the copyright owner's exclusive rights, they instead characterized it as a user's right and one which should not be interpreted narrowly. In a recent decision, and this is the case of York University and Canadian Copyright Licensing Agency, or Access Copyright. This is a 2021 decision of the Supreme Court of Canada. Justice Abella, writing for the court in a 9-0 decision, noted that, and this is at paragraph 90, the court's modern fair dealing doctrine reflects its more general move away from an earlier author-centric view, which focused on the exclusive right of authors and copyright owners to control how their works were used in the marketplace. Justice Abella notes that the court is at the vanguard in interpreting copyright law as a balance between copyright rights and user rights, quoting from Myra Toffick's work, and its understanding of fair dealing is no exception. And Justice Abella goes on to note that fair dealing is one of the tools employed to achieve the proper balance between protection and access in the Act. So fair dealing gives individuals the right under the Copyright Act to engage in certain critically important activities with respect to works under copyright protection. And in so doing, fair dealing helps individuals advance their own human rights as guaranteed under international human rights treaties, as well as those of others. Among those rights are the right to freedom of expression, including the freedom to seek, receive, and impart information and ideas of all kinds. The right to education, the right to take part in cultural life, and the right to enjoy the benefits of scientific progress and its applications. The ongoing COVID-19 pandemic has highlighted the importance of fair dealing for individuals and institutions. Required to homeschool their children, some parents likely made unauthorized copies of works for the purposes of their children's education. Older children or teachers may have engaged in similar activities. Isolated from friends and support networks and seeking distraction or connection, some individuals may have creatively reworked existing copyrighted works in ways that constitute a prima facie infringement of copyright. And seeking answers to COVID-related questions, some may have accessed without authorization copies of papers that report on studies involving vaccines, transmission, or the effectiveness of various masks. Because of fair dealing, these acts may be found by Canadian courts to be non-infringing. In addition to being an integral element of Canada's Copyright Act, I argue that fair dealing is also constitutionally required. That is to say that a Copyright Act that did not contain a fair dealing defense would be found to unjustifiably infringe the right to freedom of expression as protected under the Canadian Charter of Rights and Freedoms. I was excited to see that David Fewer and Karis Craig are both presenting papers as part of this year's Global Congress. David and Karis are two of the leading voices in Canada regarding the intersection of the Charter right to freedom of expression and copyright. David's 1997 piece, Constitutionalizing Copyright, Freedom of Expression, and the Limits of Copyright in Canada, was the first piece to engage in depth with this intersection. Karis's 2006 piece, Put in the Community in Communication, Dissolving the Conflict Between Freedom of Expression and Copyright, is also groundbreaking for its treatment of this area. In the interest of time, I'll just give my charter argument briefly, but I argue that the use of copyright protection or the use of copyright protected expression constitutes protectable expression under the Charter right to freedom of expression, in that it constitutes an attempt to convey meaning either to oneself or to others. And in the absence of a fair dealing defense, many uses of works that are seen as falling within the core of the right to freedom of expression, for instance, uses of works for the purposes of criticism or review, would be considered to be infringing and could be stopped or enjoined by a copyright owner. So key provisions of the Copyright Act, those that permit the copyright owner to stop these attempts to convey meaning, can be seen as infringing the Charter in both purpose and effect. In Canada, the Charter contains a mechanism that allows the government to justify infringements of certain Charter rights. This mechanism, which can broadly be described as a proportionality test, is contained in Section 1 of the Charter. However, I argue that in this case, in the absence of a fair dealing defense, the infringement would not be saved by Section 1, both because the provisions in question would be considered overbroad, and as a result would fail the minimum impairment branch of the proportionality test, and because the negative impact of the provisions would not be outweighed by their benefits. So as I mentioned earlier, I haven't come across any proposals that have suggested stripping the fair dealing defense from the Copyright Act. But on a practical level, this occurs on a regular basis. Nothing in the Copyright Act prevents parties from contracting out of all the provisions of the Copyright Act except for one, the reversionary right provision, and this includes fair dealing. So terms of service for websites could require parties to agree that they will not make reproductions of works in whole or in substantial part. Terms of service for platforms could require parties to agree that any content containing copyrighted work shall only remain on the site with the consent of the copyright owner. These contractual terms would limit the freedom of expression interest of individuals, but they would not engage the Canadian Charter of Rights and Freedoms, which applies only to government action. So what should be done? What are the possible reforms or possible next steps? I'd like to conclude my presentation with a few recommendations. First, Canada's Parliament should amend the Copyright Act to clarify that any attempt to contract out of the fair dealing defense is void. In doing so, it could turn to other countries to see how how other countries have engaged with this issue. Canada wouldn't be the first country to limit the ability to contract out of the fair dealing defense. And Canada could build on those existing efforts to ensure that the fair dealing defense remains available. This would require amendments, to both the Copyright Act generally, but also specifically in the context of provisions involving technological protection measures. Second, it's important for Parliament to start to see its role within the Copyright Act, not just as protecting the rights of the copyright owner or as preserving a balance between authors' rights and users' rights, but as something different, as creating and preserving the conditions through which individuals can participate in culture. And doing this, I think, it would be a significant shift for Parliament, but an important one if we are to make the Copyright Act one that is equitable and an act that works for everyone. So looking at its role through this lens, through a lens of creating and preserving the conditions through which individuals can participate in culture, could lead both to this specific reform, ensuring that parties can't contract out of fair dealing, along with other reforms as well. Third, perhaps it's time to revisit the question of whether the Charter ought to apply to the actions of private parties as well as to government action. So as I mentioned, traditionally, the Charter is seen as only applying to government action. This is based on the idea that government is the entity that poses the most significant threat to individuals. As we've seen in a number of contexts, private parties, private entities can also pose significant threats to individual and collective liberties. And so perhaps we need to think about whether the Charter could be interpreted differently by courts as not just applying to government action, but applying in certain contexts to the actions of private parties as well. And fourth, let's start to really rethink how freedom of expression is conceptualized to ensure that a core element of this right would involve support for the ability of individuals to be heard. To think about freedom of expression not just as a negative right, but as focused on the ability of parties to be able to engage and to participate in culture. I'm going to end my presentation here today, but I just wanted to make this as an invitation to be in touch. Please feel free to get in contact if you have any comments or any questions, or if you'd like to continue the conversation. This is a research area that I've been focused on for a number of years, and one that I'm would be very happy to engage with anybody to talk about. So please feel free to get in touch. My contact information is reynolds@allard.ubc.ca. So thank you very much for tuning in today. I'm really excited to see the other presentations. Thank you so much to the interpreters for working with me to help disseminate this specific talk to a broader audience, and for putting up with my attempts to talk slowly. So thank you very much. I'll sign off here, but again, I'm grateful for this opportunity to present to you today. Thank you very much.